and Mr. Adam Gurley. And I think you both are here. And forgive me, Ms. Corioso, I don't know if I butchered your name, but just to remind you all, we're given 20 minutes for each side to make their argument, and you could reserve up to 5 minutes for rebuttal if you are the appellant. And with that, we are ready to proceed. And how do you pronounce, I apologize, how do you pronounce your name?
Corioso, thank you.
Corioso, very good, thank you, ma'am. I'm sorry?
You were close, thank you.
Okay, thank you. All right, you may proceed, ma'am.
May it please the court, good morning. My name is Margaret Brennan Corioso, and I represent the appellant, Mr. Theodore DeLong. At this time, I'd like to request 5 minutes for rebuttal.
Very good, ma'am.
Trial court erred in this case by granting summary judgment for the association because there are multiple material facts in dispute regarding Mr. DeLong's affirmative defenses and his counterclaim regarding the validity of the lien and the enforceability of the lien. The trial court also erred in finding that the business judgment rule applied in this case. This case involves the foreclosure of 2 one-week timeshare units.
And can I just cut through the chase and get to the heart of the argument here? And I've worked with both Judge Valenti and Judge Atkinson before, and I know very well that they're very familiar with the facts of this case. My main concern, I want you to address this. The court went ahead and even though found liability in this case, basically reserved the issue of the amount of damages later on. What concerns me, why isn't this a non-final order that perhaps this appeal may be a bit premature? Can I have you address that for me?
Yes, Your Honor. So the reason why this it can be conceived, and we actually did file a reconsideration motion in the trial court to see if it was a non-final order. It was a partial summary judgment. However, the problem is that when the judge entered the judgment for liability, that means that the judge was finding that the association proved or disproved the affirmative defenses that the lien was valid. Now, a defective lien is a complete defense to foreclosure. So in order to determine that a liability for foreclosure, the judge has to determine that the lien is valid. Now, if, looking at the record, it is very clear that everybody had an issue with how they got to the amounts of the lien. And even if you look at the trial court's ruling on page 1373 of the record, the judge said, I have one sticking point here. I just can't get around the $12.17 a week. I just can't. Mr. Wachovia mentioned in passing that it would be like the Bank of America seeking to foreclose on a house that's $3 million for a $180,000 home. Something isn't jiving here. I cannot reconcile the reasonableness. I'm leaning towards bad faith. It doesn't make sense. It doesn't make sense. So, Your Honors, in order, the whole point of our affirmative defenses is the fact that we're challenging that the lien was not valid. And if the lien was not valid, if it was a willful exaggeration of the lien, like we don't have a mortgage here. It's not a specific contracted amount. So in order to determine whether the lien is valid, you have to look to see whether it was a willful exaggeration. The lien
can't the judge, let's just assume this, because the judge basically in the order said, I'm reserving jurisdiction for a full evidentiary hearing. Couldn't the judges come back and say it's zero? If the amount is zero?
If the judge did that, though, there is still the judgment that has been entered finding liability here. And then therefore, my client not only would be, could possibly be responsible not for prevailing party attorney's fees, but also would have to go through the hearing. Those matters should be determined at the same time. And Your Honor, in case if you are concerned about the fact that it is a non-final order, this court, and actually I believe Your Honor was on the opinion in the Ferry v. Wholesale case where, and actually in that case, it was a partial summary judgment of a non-final order with facts very similar to ours. And in that case, this court treated it as a petition for writ of certiorari and found, and in that case, that what had happened is that the trial court entered a partial summary judgment. This court came back and said there's actually an affidavit that raises a genuine issue of material facts is an essential departure of the law, which is very similar to what happened in this case. In this case, we also had an affidavit of Mr. Flynn that conflicted with the affidavit that the association put forth. And therefore, that goes to the point. That affidavit would show that the budget was improperly inflated, and it directly contradicts with the affidavit that the association put in. So if this court could, if it considers it a non-final order, we would ask that you treat it as a writ of certiorari, find that there is an essential departure of the law, and that this court follow the Ferry case and say that there is a genuine issue of material fact. Everybody in this case had a problem with the amount. My client is not saying that it didn't owe the assessment. In fact, my client tried to go to the court registry on page 1121 of the record and pay the amount of the assessments of the $600 and something that my client thought that it owed. The problem that my client had with it is the amount that they assessed them, and the record is has a lot of facts in dispute regarding the reasonableness of this, and showing the reason why the association was trying to get rid of. They wanted to get rid of all of the timeshare. They actually.
You're kind of arguing the facts now, aren't you? That you argued below. Doesn't this come down to whether or not the order granting summary judgment accomplished anything? The only finding I see in there that I think you must be agreeing with, your client failed to make any payment of any assessment in any amount. So your client agreed there was some amount due and still didn't pay that, and didn't pay it into the court registry. Is that true or false?
My client attempted to pay it into the court registry. The court registry would not accept. And if you look at the transcript of 1121, they did attempt to do it. The problem is the affirmative defense that my client raised is not that it didn't owe the amount, was the amount was woefully exaggerated. And the law, as far as liens.
Well, I mean, basically, you're going to end up with a trial de novo when the court reserved jurisdiction for every single thing you've raised, including attorney fees, interest, amount. I'm not sure that this order is a model of clarity or efficiency, but I just don't know what this order accomplished, other than saying your client owed something, we don't know how much, paid nothing, and you're saying, well, he attempted. An attempt to pay is not a defense unless you filed a motion to pay and the court said, nah, you don't have to pay. That didn't happen, right?
Our affirmative defense, though, was the fact that the lien was not valid. And the law is clear. A lien is not valid, it can be dismissed, that it's fraudulent, that it's woefully exaggerated, and that should be dismissed. So therefore, if that lien was not valid, then our request for relief would be to send it back to the trial court to dismiss the lien, and therefore it shouldn't even go forward to determine the amount of damages. That is one of the options of relief that we are seeking here today. And so
you don't think an option available to the court is to dismiss this at the end, say, you don't know anything, I'm going to dismiss it? You don't think that's an available option?
That was before the court is sufficient to show it was already a willful exaggeration, and it shouldn't even go to the point of having a trial on this matter. I think that everybody had an issue. There is no question, even the association, as far as when they were asked about how they came up with the budget, they said, never has there been a budget of $2.6 million. This budget does not reflect any shape or form what the budget is. Couldn't explain what the numbers were when they were asked about specific things in the budget. For example,
Ms. Carrasco, can I interrupt right now? We seem to be having some technical difficulties. Let me pause right now and give, I think one of our panel members is having difficulty with the voice. So let me just have him come back in again. I apologize. As I mentioned before, sometimes technical issues do occur. So thankfully, we have a lot of time to address this. Are you in a better position? Can you hear
me?
We could hear you now, because
Okay.
I know you. I gathered that you were attempting to ask a question and I couldn't hear you. So thank you, Ms. Cuscaros. You may proceed.
I apologize for the eruption to your argument.
No problem. Go ahead, ma'am. Thank you.
Your Honor, as I was stating, the record shows multiple material facts in dispute, even when the depositions that were submitted in support of the summary judgment of Ms. Caruso, who was the director of the association, she was asked about specific amounts. One of the specific amounts was the expenses, which included maid services. And on page—
Doesn't this kind of dovetail with the jurisdictional argument, meaning the finality of the appeal? In other words, what you're claiming is in dispute. Well, you're also claiming the reasonableness as far as the business judgment rule is true dispute, but much of what you're claiming is in dispute has not even been resolved, which is the amounts, what the amount should be. There was express reservation to determine those matters that you're now claiming are still in dispute.
Your Honor, yes, that is correct, except for the problem is that the trial court did enter a judgment of liability. And that has a lot of effects on my clients. That means that they are saying that's liable. And our affirmative.
Well, let's talk about effects for a second also, because I'm not, wanting maybe you do to put your arguments into silos when it comes to the appealability issue. And one of them you mentioned was certiorari, and you talk about effects, but for certiorari, the effect has to be an irremediable upon plenary appeal after a final judgment is entered. And why would these effects, what needs to be addressed now that can't be addressed on plenary appeal for the purpose of invoking certiorari jurisdiction?
So one of the things that we are asking for is for this court to actually find that the lien was invalid and to actually remand it back to the trial court to dismiss it. So there should not actually even be a hearing on the amounts because it was a willful exaggeration, and that's a complete defense.
Is that the type of irremediable harm that this court considers sufficient for certiorari jurisdiction, not having to attend a hearing in a civil case?
It's not the not having to attend the hearing, but it's the waste of judicial resources. It's the additional attorney's fees that if this court could address this now, and if this court does not agree with our position that it needs to be dismissed, then at least it leaves open whether or not the client is liable. If not, if it goes back and even says zero amount, that judgment for liability has still been entered. There is still a judgment against my client saying that they're liable. And my client's position is that the lien is invalid. It was willfully exaggerated, and therefore that it should be dismissed. So,
but that goes back, and if I could follow up with Judge Atkinson, for certiorari, when you've mentioned about, well, my client will expend attorney's fees and judicial resources, those specific matters had been held not to be appropriate under certiorari, because the whole key of certiorari that you can never be able to raise that issue on appeal. So everything that you're making reference to in terms of the liability part of it, in terms of the grossly exaggerate, all that could be argued on a plenary appeal. And so my struggle is that right now at this juncture, based on this appeal before us, we're dealing with an order that is non-final. Very clearly, the court has reserved jurisdiction to hear everything that you're arguing right now. The court hasn't made a ruling yet. And in terms of liability, that's preserved for you when you do file an appeal, for a plenary appeal. So that's my struggle, and I think it follows what Judge Atkinson was asking.
I understand your concern, and if the court is going to take a position, our request would be that this court would remand to the trial court to set aside the liability judgment and to determine those things together. And so that way the liability judgment would go away. However, Your Honor, there is also case law, and as I mentioned, I know I talked about the Ferry case that Your Honor was on, the petition for certiorari, but there are other cases with similar facts too, where the court has decided to do piecemeal review. The Fischel v. Tanglewood case, and in that case, they determined that determining the validity of a lien was a determination, and they actually found that there was genuine issues of material facts, and on that case, they did. So there is precedent for setting aside. Like I said, the Ferry case also had to do with a partial final summary judgment on a lien that they found willful, and this court did find there was a genuine issue of material facts because of an affidavit. Also, this court in Gator holding, they also issued a petition for certiorari on similar facts too. So there is precedent for what we're asking this court to do. So again, our main concern is the fact that the judge entered the liability. And by saying that, the court is saying that the association conclusively disproved the affirmative defenses, which the association did not do in this case. Our affirmative defense was the fact that the lien was inflated and that they did not include the things that they needed to. And even by the judge court's ruling, you could see that the lower court was struggling with the amount. Even the attorney for the other side said that amount has no bearing. So where these numbers come from, it is a concern. And so there shouldn't have been entered a judgment of liability. At the
Well,
very
can I ask you to elaborate on your argument? So it's not an uncommon occurrence to enter summary judgment on a partial summary judgment and then have determine that evidence needs to be adduced for some other aspect of a dispute, right? So what you're saying, it sounds like there that as a matter of law, or I guess you're saying there were material disputes of fact regarding
the affirmative defense.
the affirmative defenses. Now, but this goes to what Judge Valenti was saying. Is there any of those affirmative defenses that would actually achieve the conclusion that there was no lien whatsoever? They had no entitlement to a lien. I mean, your client failed to pay assessments correctly, correct? Am I correct?
Yes, but if the lien was a willful exaggeration, then the defense, that's a complete defense. That means that lien should be dismissed. That means they have to go back and start again. It doesn't mean they get to say, no, it's $200. That there's a huge difference here between a mortgage that says you owe this specific amount and an assessment that goes from.
Could the trial court have determined that based on undisputed facts that it was not a completely invalid lien, that there was some amount?
No, Your Honor. The amount of the assessment was for $12,750, actually $25,000. My client's claiming that the amount of the lien should have been $600. The trial court wouldn't even.
You just said right there the amount of the lien should have been $600. So there should have been some lien. You can't just say that there's no liability whatsoever all of a sudden.
If we were to have a policy regarding that means that any contractor could say, even though you only owe $1, I'm going to bring a lien against you for $1 million. And the fact that you haven't paid that $1, we should enter a judgment of liability. That's the whole reason why the case law is specific, that if there's a willful exaggeration, then the lien should be dismissed. And that's what.
And if I may, ma'am, let me interrupt you. No, because I've given you an extra minute because of the technical difficulties, but now you're about to really hit your rebuttal time. So I want to be able to give you fair warning on that, okay?
Your Honor, if I may use a couple minutes of the rebuttal time just with business judgment rule.
Yes, ma'am.
So the association is going to take the position if this court finds that that the trial court, that the association, the budget wasn't correct, but they were allowed to do that because they followed the direction of the director. Our position is, and in the case law from this district, it is clear that there's a two-part step to the business judgment rule. But first, that the decision has to be, they have to have authority to do it, and second, that the decision has to be reasonable. Our position is that they didn't meet the second part of it, and that the record, there are multiple material facts in dispute regarding that, and that the reasonableness is actually a question of fact that should not be determined on summary judgment. And we ask that this court look at the Garcia case from this court, and also the Royal Harbor case, where in both of those cases, and actually most of the cases that the association cited to, while they cited the correct rule, all of the courts did reverse most of them back to determine the reasonableness, because there were genuine issues of material fact. So, Your Honor, for those reasons, we respectfully request that this court reverse and remand and find that the lien is defective on its face, and ask the trial court to dismiss the lien, or in the alternative, to reverse and remand for the trial court to set aside the liability judgment and determine the material issues of facts regarding the damages at a trial. Thank you, Your Honors.
Okay, very good. I mean, I'm going to give you your 2 minutes for rebuttal, okay? Very good. And I'm going to trouble you to please mute your microphone. Mr. Gurley, you've unmuted and you're ready to proceed. Please proceed, sir.
Thank you very much, Your Honor. May it please the court. My name is Adam Gurley, and I represent Paradise Lakes Condominium Association Incorporated, who I will refer to throughout as the association. At the outset, our argument, as the court touched on, is that this appeal is premature for all of the reasons that the court stated. So I'll clarify a couple points briefly on that argument. We, of course, have a summary judgment order, reserves jurisdiction as to all the pertinent issues. The claim that the invalid lien argument is an absolute defense to foreclosure doesn't apply here. We don't have a foreclosure judgment at issue. And the Fisher versus Tanglewood case out of the 5th DCA that was cited by Appellant's Counsel, in that case, the court had entered a foreclosure judgment and then found that it was appropriate to address that judgment on appeal because there was a pending foreclosure. We have no such judgment here. That case doesn't apply. It was pointed out that at the evidentiary hearing that the court expressly reserved jurisdiction to conduct to address these issues. The court could very well rule that we're entitled to $0 and that the other side is still the prevailing party. Not only that, but once a final judgment is entered, if a final judgment is entered addressing the exact dollar amounts plus the foreclosure lien issue, there's nothing stopping the appellant from appealing at that point as to all of those relevant issues. They can appeal as to liability, as to the amount of damages, and as to the validity of the lien and the appropriateness of the foreclosure judgment. So all of that is on the table once this is appealed at the appropriate time, which is after the court conducts this evidentiary hearing.
And I have a question, a silly question. Was there a motion for rehearing filed? Say, Judge, you're kind of messing us up here. Give us a better order.
There was a motion for rehearing filed, and it was a motion for clarification as well as to various issues, including, what exactly is going to be reserved at the evidentiary.
Was there an order entered?
There was an order, and it was simply denying that motion.
Okay, so it didn't help you.
It didn't help us clarify, but I think in large part, and maybe it's not the most clear order, but I think we know what we're headed in to argue. It's that there's liability. Mr. DeLong, the appellant, owes us something. What is that number? And once we determine that number, is the lien valid based on that number? Is it
Well, the judge didn't cover whether or not you can raise the defense of attempted payment to their amount and that the clerk wouldn't take that payment. The judge didn't cover that in the order. So I'm just curious what your take on that is.
Well, the judge didn't cover that in the order, and frankly, we object to that being referenced as part of this appeal because there's nothing more than a discussion in the record. But
well, it goes to your argument that the appeal is premature.
Well, and I think, I'm sorry, Judge.
No, that was my question. I think you can address that. I think it is kind of included in the premature appeal aspect.
Well, and I think the question is, did they ever file a motion to ask the court to put that money into the court registry? Did they ever file a motion with the trial court asking to secure a bond to satisfy?
Well, I asked that question in a roundabout way, and their answer is, hey, it's still an affirmative defense. So I mean, nobody argued case law, the judge didn't cover it. I'm kind of like up in the air on that.
Okay, and so I don't think that precludes the summary judgment that was entered, an attempt to put money in the registry. You have to put money in the registry or you don't. You make a good faith effort to show the court that you are going to.
Isn't that a factual dispute that you normally don't eliminate by summary judgment if there's an attempt in good faith? The judge didn't cover that.
No, the judge didn't cover it, but I don't think even if the court were to find that there was a good faith attempt to pay that into the registry, I don't think that goes, I don't think the attempt to pay it into the registry where it was denied by the clerk constitutes a true good faith attempt. I think.
Well, okay, so what it sounds to me, you're willing to agree with her interpretation that everything's on the table. If everything's on the table, then the appeal is it is premature if everything can go back. If she's worried about the liability and you're saying it's on the table, then we really don't have a dispute here. If you're saying there is liability, that's determined, that's set in stone, you can't reserve jurisdiction and come back and eliminate liability. You can come back with zero because they have a defense that they paid it or something. But so what's your position on that question? Is there a liability on the table or not on the table?
I believe the liability has been determined as a result of this order that is here in front of the court now. And the issue moving forward is what is the amount of damages? We have liability that's been established. What is the amount? And then will that be set for a foreclosure?
Are there any affirmative defenses that would that if the defendant prevailed upon them, would eliminate liability, or alternatively, I guess, bring it to zero. I don't know if that's tantamount to each other, but that could still be determined pursuant to the evidentiary hearing.
I don't believe so on the issue of liability, Your Honor. I believe the court's ruling looked at the business judgment rule and said, is the budget itself reasonable? And that was the standard. Is it reasonable? If it's reasonable, then it's valid. It's a valid budget. It's a valid lien. Now we go back to the trial court on the issue of amounts. And the trial court can say, you know, this amount's a little high, this amount's a little low, and change those amounts. But the question before the trial court was, looking at the evidence in opposition to summary judgment, is there anything that shows under the business judgment rule that this was unreasonable? And the trial court correctly concluded, no. All of the evidence before the trial court shows that the association went through this long process with DBPR, the Department of Business and Professional Regulation Oversight. They worked with accounting firms. They worked with their legal counsel in preparing this budget. So the court said, your affirmative defense is wrong. There's no sign that there is bad faith. There's no sign that it was arbitrary or capricious. It's a reasonable budget and therefore a reasonable lien. The trial court reserved to potentially take a second look at those amounts and change the amounts, but minor changes in the amounts and a good faith dispute as to the amounts does not make the lien invalid.
So to be like frank and above board, what you're saying, the ostensibly exorbitant amounts that the trial court, he didn't use this term of art, but or he or she, I forget, he didn't use this term of art, but considered hinky. Those are not going to come down much, right? Because the way that giant number is going to come down has already been adjudicated away. She's just going to be, on behalf of her client, going to be able to chip away at the margins, right? And then it's going to come up here on plenary appeal, and she's going to get to argue that that initial decision on liability itself was improper.
Yes, Judge. The finding was that the numbers on the budget were not unreasonable, and then that there could be some changes. But I think a clarifying point that's important here is counsel read from the trial court's ruling or the trial court's conjecture during the hearing when looking at that budget and said, I can't reconcile this $2.6 million number. But that wasn't part of the judge's ruling. At that point in the hearing, there was a discussion and a review of the budget on the face of the budget, along with the Excel sheet from the DBPR that was used to formulate that budget, the DBPR's Excel sheet. And when the court went through the math on the budget and went through that Excel sheet and said, okay, I see now how the numbers were determined, at least mathematically. I can see from this spreadsheet that the discrepancy here is the fact that the total assessments for 4 timeshare units over 204 timeshare weeks was only divided between the 5 unit owners who still own timeshare weeks. So they had to pay for all 204 weeks. And that's why they're paying $12 grand and $700 in assessments per week.
And if I may, Mr. Gurley, even with all of that, I guess what I try to see, what's before us right now? Before us right now, is this a proper appeal? Is this a proper method? You know, appellate counsel wants us at this juncture, even though it's a non-final appeal, to make a determination as to whether or not the liability portion of the order was appropriate. But all of this could be raised on a plenary appeal, the issue regarding with the appropriateness of the actual liability. And our courts repeatedly, we do not allow piecemeal appeal. And I know counsel made reference to a certiorari, a case where our court did. Well, certiorari is far different. And just because you're going to have to go through and undergo judicial labor and undergo attorney's fees, that by itself is not the standard. So I guess for me, regardless of all of that, the question for me is very simple. Do we have jurisdiction to review it at this juncture? Is this a non-final order? They could, everything that she's raising right now could be raised later on a plenary appeal. That's what I want you to address for me, Mr. Gurley.
Your Honor, I agree that this is a non-final order, that this court does not have jurisdiction to review this non-final order at this point in time. I agree with that 100%, that this is a premature appeal. All of the issues that are here before the court could be addressed and should be addressed after we have a final judgment. There's no harm to the appellant by waiting until that point. He can object to the foreclosure, the liability, the lien, all of those issues. So to directly respond to your question, I do not believe there is jurisdiction to hear this appeal. I believe this appeal is premature and that is a dispositive issue, and this appeal should be dismissed on that basis alone. I'm prepared to address the reasonableness of the budget as I got into there a bit. I'm prepared to address the business judgment rule, but I don't believe we get there.
Judge Atkinson, did you have a question? Your
Well,
friend.
yes, yeah, why don't you take unless my colleagues have another question about our jurisdiction, let's take make your argument. Why, if we were to reach the merits, there is not a material issue of fact that prevented summary judgment, or why on the undisputed facts, your client wasn't entitled to summary judgment as a matter of law.
Absolutely, Your Honor. And so the affirmative defenses and the counterclaims are really the issue here. As we've stated, there's no dispute that Mr. DeLong, the appellant, never paid any assessments. And those affirmative defenses, counterclaims, they can really be summarized together. It's really, did the association incorrectly or negligently prepare this budget? And the trial court applied the business judgment rule and said the standard isn't incorrect. Was it unreasonable? And the trial court correctly found that the budget was not unreasonable. And so we look to the business judgment rule, and we know that it's afforded protections to individual directors, and those protections have then been extended to boards as a whole making decisions on behalf of associations. As appellant's counsel pointed out, when we're looking at the business judgment rule in the context of a board decision on behalf of the association, two criteria. One, whether the association has contractual or statutory authority to perform the relevant act. Here, they have a statutory obligation to draft a budget, prepare a budget, impose assessments, collect assessments, and then lien for unpaid assessments. No question, no disputed issue there. The second one is what it really comes down to. It's if that authority exists, whether the board's actions are reasonable. Reasonable meaning arbitrary, capricious, or in bad faith.
Was there any, let's clarify maybe facts. Was there any increase in costs, or was the increase in the assessment purely, could it be said, based on the summary judgment evidence, that is purely a consequence of this, for lack of a better way of explaining, the reconfiguration of I don't want to say liability, but of responsibility? You know, in other words, the association didn't have to pay for its own portion, that its for its the units it owned, and therefore those were distributed between among the unfortunate remaining owners. Can you say that? Can you say that there was not an appreciable interest in the cost themselves? They didn't start paying 3 times the amount they used to pay for the maid to clean the common area, for instance?
I can say that, Judge. The assessments, in fact, for the 2014-2015 budget, they totaled per unit week $311.72. The prior year budget, as cited in appellant's own brief, was $291. So they went up $20 the following year. If we multiply, and also in the appellant's brief, they note that Mr. DeLong's assessments over the period of the prior 6 or 7 years were between $200 and $400. So at $311.72 for the 2014-2015 budget, we're squarely in that wheelhouse. There's nothing unreasonable about it. The fees went up $20 a unit week.
But you're arguing the facts, aren't you arguing the facts? And we don't have a ruling on facts. I mean, ordinarily, tell me if I'm wrong, a summary judgment is not entered without ruling on the affirmative defenses or the record showing by affidavit or pleadings that the affirmative defenses are bogus as a matter of law. The judge didn't say anything. Maybe those affirmative defenses would prevail. I'm not saying they would. I'm just saying I'm not sure the judge entered an order that was appropriate for summary judgment. And that's my dilemma. I mean, her defenses could have been raised as a preemptive strike in a preemptory challenge. She could have filed an initial action on her own, but that wasn't done, a declaratory judgment action, for example. So we're stuck with this bizarre order. I've never seen one quite like that, that basically says, I'm going to do summary judgment, but it's only liability. I'm not going to use that term. I'm reserving everything else that you have to rule on before you can get to a summary judgment. So the judge didn't rule on anything that was contested and entered a thing that we suppose is on liability, but we're interpreting that to save the order. So that's kind of my frustration and my question. If you want to answer that further, I think you've probably answered it already, but it's your turn.
Sure, Judge. And I also think that the order, in addition to establishing liability on the part of Mr. DeLong, it also shoots down their counterclaims and their affirmative defenses under the business judgment rule. So I think an important part of that order was that there may be a good faith dispute as to numbers, but there is the association's record evidence as to the reasonableness, the procedure they went through, the committee they used, the board approval, their LCAM, DBPR's oversight.
Where does the order say that?
It doesn't say that expressly. It says that under the business judgment rule and their reliance on the DBPR, when citing the business judgment rule as saying the business judgment rule applies in this case. And so that, I think, is the important part of the order. It's liability, and that's tied to the fact that the budget is reasonable under the business judgment rule. There's no showing whatsoever on the other side that there was any underhanded, capricious, arbitrary action, or that the budget is in any way arbitrary. We have all of these facts that the association presented that said here was the process, and we followed the DBPR under threat of fine. And I do think the order is specific enough in that it does say the business judgment rule applies. The association relied on its experts in the DBPR. And so we find that there is liability here. And so I think the court did lay out at least enough to say under the business judgment rule, this was reasonable. And that's why there's liability as to some amount. And those amounts could change. But even if they do, it doesn't amount to capricious, arbitrary, bad faith. We have a reasonable.
Let me ask you this. So you're saying the amounts could change, and I was kind of creating a distinction between artificial, or it's not artificial, but a distinction for it's ad hoc, a purpose of this discussion between more structural issues regarding the budget and actual just qualitative versus quantitative. How much do you pay the cleaning service versus who is responsible? Now the structural, that's the fulcrum point, right? The giant change had to do, you just established that, or you're saying, it didn't have to do with, paying the pressure washer guy more every year. It was the fact that now it's distributed among fewer responsible parties. So is that subject to change at the evidentiary hearing? In other words, it just by virtue of saying, well, the way they did it was reasonable, meaning I'm going to eliminate, or I'm going to enter summary judgment against the affirmative defenses and counterclaims because the business judgment got it over this threshold of reasonability. However, at the evidentiary hearing, is that still something open to debate, whether it was proper to, for instance, not require the association to pay its share for the properties it owns?
And I believe,
Mr. Gurley, you go ahead and respond to that question, and then you would have exhausted your 20 minutes. But go ahead, Mr. Gurley.
thank you, Your Honor. Your Honor, I think first, the question would be under the business judgment rule and the Miller versus Homeland Property Owners Association case is, what did we rely on at the time that we made this decision? And we relied on the DBPR forcing us to adopt the budget in that way. And so I think that's already been addressed at this point.
Okay, it's been addressed for the purpose of whether it's reasonable so that you can rely on the business judgment rule to establish at least liability that the lien was valid. But that doesn't mean it was. Does that mean that the defendant at the evidentiary hearing can say that it was wrong? It may be reasonable to rely on DBPR and on the accountants, but it could be wrong. Is that still open for debate at the evidentiary hearing?
I think they can certainly raise the question. I mean, it would just incite our same response, that we're under the business judgment
But they
rule.
could prevail, right? They could say, well, yeah, you guys were reasonable to listen to your accountant and the DPR, but you know what? They were wrong, right? And then there could be an amount considerably lower. So that goes against what I was saying before. He may not be able just to chip away at it. He may be able to turn the tables still.
Exactly, Judge. And I think that gets us back to why this appeal is premature. Until we know what the judge is going to do with those numbers, we can't really make a decision as to whether, those assessments were properly applied to those 5 owners, and whether, the lien is fraudulent based on those number changes. So I think it gets back to the premature appeal argument. We just don't have that ruling from the judge yet.
Very good. And on that, Mr. Gurley, you've exhausted your time. I'm going to ask you to please mute your microphone. And counsel, you have 2 minutes for rebuttal. I've reserved you the 2 minutes. So whenever you're ready, go ahead.
Your Honor. And Your Honor's questions exactly hit our concern. The concern is the fact that the judge did rule on the liability issue, and that those are not going to be open for discussion when it goes back. And that was actually our affirmative defense. And the association did not conclusively refute our affirmative defense. If we were to go back to the court, we would ask that this court.
Well, let me ask you. You just said you just contradicted what your opposing counsel said, I think, to my question, which is assuming that the trial court said that there, as a matter of law, your affirmative defenses to the validity of the lien were eliminated, and your counterclaims were eliminated because, based on the business judgment rule, he said the undisputed facts entitled them to a judgment as a matter of law that it was reasonable to have established these amounts. But I believe your opposing counsel just conceded that at the evidentiary hearing to come, you could still say, well, it was wrong. It was wrong. And forgive me if I'm butchering the process, but it was wrong to not require the association to pay the assessments for the property that the association owned, to put it all on these two weeks that my client owned. Is that true?
My concern is that it's going to go back to the trial court, and the trial court is going to say the appellate court affirmed the liability judgment, and we're only determining damages. We're not going to look at the validity of the amounts. And Your Honor, you asked a question.
Well, then what we all read the order, and that's kind of now they're really dovetailing these issues. What did he reserve judgment on then? What did the trial court reserve judgment on?
The amount of damages. And we did file a motion for a hearing for this reason, and said this looks like a partial summary judgment, but we're confused as to the liability. The amount of damages do go to the liability, and we asked the judge to address that, and they didn't. That's our biggest concern, is that the liability has been decided. Your Honor, you asked a question regarding if there are any amounts in the budget that are significantly different, not just spread out, and there are. For example, in the 2014 order, they charged $7,000 for maid services. In 2013, it was only $1,500. So for somehow, even though they said that they didn't do any rentals, they upped the price over $6,000 for maid services. So it does go to show that it wasn't.
Okay, well then but just going back to now that you will be able to argue in this case.
Able to get to the point that the claim of lien should be dismissed because it was willfully exaggerated, and to show that the association's decision was not reasonable. And the question of reasonableness is. And
if I may, ma'am, I let you go on and on and on. And I know because Judge Atkinson's been questioning, but finish that thought, and I think we'll need to conclude, okay?
Yeah, so just to address that one point regarding the reasonableness, that is a question of fact that should not be decided on summary judgment. And that's what we're asking this court to do, is to send this matter back, set aside the liability judgment, hear the matter on all of the material facts, as there are a lot of material facts in dispute. So respectfully request that this court reverse the summary judgment and remand for a hearing setting aside the liability judgment. Thank you.
Very good. Well, thank you all at this time, and this will conclude the virtual oral argument. Thank you all for attending. All right, so at this time, the court will stand in recess.